Welcome back to another Frequently Asked Questions Friday video where we answer your questions regarding elder law and estate planning and estate administration. So today's topic is, what is a double probate? Now, I don't know that this is actually a term that anyone else uses, but I do use this term. And for me, it means two things. Number one, it means a married couple where we have to go through the probate process at the death of the first spouse and at the death of the second spouse. The second way we can have a double probate is where we have probate in multiple states. In my opinion, both of these situations should be avoided. We'll tackle the multiple state case first. It happens a little bit less frequently than the double probate due to going through probate twice for the same married couple. So typically this happens when people own property in multiple states. So for example, they're residents of Pennsylvania and then they own property in Florida or some other state where they vacation, or just have multiple residences somewhere across the country. The reason why this is a double probate case is because if this is the case and you don't have property titled in a trust or titled jointly with another person in some manner that escapes probate, this property will end up causing probate in both of these states when the person passes away owning the real estate in this manner. So we try to avoid this, and typically for these cases the answer is some type of trust planning. The next type, which I've seen more frequently than ever in my career, are married couples where each spouse has accounts that are solely in their names. These could be bank accounts, these could be investment accounts, or they could be bonds or CDs, many different types of assets, and also, again, real estate. So this is less than ideal because many times when people come in to see me and they're married, their plan is not to go through probate twice. They want everything to go to their spouse when they pass away. And it's not done by design. It's just that they each kept things separately, or perhaps they received an inheritance at some point in time and then never retitled the assets in their spouse's name as well. So in these cases, many times we solve this through retitling the assets. In other cases, we can solve it by beneficiary designation. So if the spouse doesn't want their spouse to be on the account as a joint owner, we could make the account transfer on death to the spouse and still avoid probate at the death of the first spouse. Trust planning is another option for this. For people who are doing trust-based planning instead of will-based planning, we certainly look at this and try to make sure that everything is taken care of, and usually lean on the trust to do it in those cases. Both of these cases of double probate are something that I recommend avoiding, and when I have people who come in and are married and express that they just want to leave everything to their spouse and they have assets titled solely, we try to work to figure that out. I will note there are cases where married couples may want to go through probate twice. This could be because they each have children from prior marriages, and choose not to do trust planning, which could resolve that issue. So there are some cases where people would do this by design, but most of the time when I see it, that's not the case, and we should try to avoid it. If you've got questions, we'd love to hear from you. Just leave us a message on Facebook, send us an email, or reply to the video when it's posted on YouTube. Thanks.